afternoon. My name is Stacy Blakeley, and I am the Executive Director of the Policy Circle. I am so glad that you've taken time to join us for what promises to be an informative, engaging, and maybe even lively Move the Needle program today. The Policy Circle's mission is to inform and equip women to be more impactful and effective civic leaders. Our goal is to make sure that women are courageous, informed, and can take ownership to solutions to the issues facing their community. And today we are tackling an important topic, antitrust. And our goal is to bring clarity to this complex issue because there is a recent wave of antitrust legislation and litigation that will most definitely impact us as consumers. And there is unusual bipartisan support for this antitrust drive that really seems to be motivated by a shared mistrust of big tech on both sides of the aisle. So the Policy Circle recently published a brief on antitrust. So I encourage you, if you haven't done so already, to please read the brief, share it, and then perhaps host a conversation with your network on this issue. So antitrust laws are designed to protect and promote competition. It's guided by the principle that consumers are better off when companies battle for our business, that we get better services and prices. So let's take a look at a quick video that explains key concepts in antitrust.
The antitrust laws are the laws that we in the United States have on the books that prevent anti-competitive behavior and keep markets functioning for regular consumers. What do they principally do? They forbid collusion. When firms get together and say, we're going to all charge $15 instead of setting their own prices and competing with each other. They forbid anti-competitive mergers, that is to say, mergers that lessen competition. So I'm going to try to buy my direct competitor so that I don't have to compete with them, so that I can raise prices or lower quality. And the third thing that's forbidden is monopolization, which is when a usually large firm or a firm with market power uses that market power to push out a competitor, to keep a competitor in a niche.
So antitrust really should matter to all of us, not only because it can impact us as consumers and citizens, but we have to think broader in terms of the impact that this proposed legislation could have on the U.S. As our global competitiveness comes into play. And we want to see how competitive our businesses can be in a global market. There are multiple sides to this debate, so let's jump right in with our first panelist, Debbie Majoras. She is the Chief Legal Officer and Secretary for the Procter & Gamble Company, where she leads a global legal department of over 500 lawyers and other professionals. Debbie previously served as chairman of the U.S. Federal Trade Commission from 2004 through 2008, and prior to that, as principal deputy for the U.S. Department of Justice Antitrust Division from 2001 to 2003. Debbie, thank you so much for joining us today.
Thanks, Stacy. Happy to be here.
Well, we're really looking forward to getting your insight. And really, let's start. As former chairman of the Federal Trade Commission, can you explain the role of the federal government as it relates to antitrust?
Sure. Well, of course, Stacy, it starts with Congress. And I know Barbara will talk a little bit in more detail about that. But, Congress really set the antitrust laws we abide by today in the late 1800s and early 1900s, and they haven't changed much since then, which actually reminds us that they are quite adaptable. Now, some people are arguing with that today, and we'll talk about it. But to turn to the two federal enforcement agencies, with which I'm quite familiar, having worked at both, we have two antitrust agencies in the United States. Why? Well, decades ago, when Congress did not believe that the Department of Justice was enforcing the laws vigorously enough, they added the Federal Trade Commission. And so the way I would view how they do enforcement is their job is to act as referees in a competition, right? Not there to pick winners and losers, but there to take a set of rules, if you will. Now, it's not quite that simple because in our legal system of precedent, the statutes are really quite skimpy when you read them. You can't just open it up and say, oh, there's the answer, right? But as with all of our laws, really over time, the courts have put the flesh on the bones and said, here's how we're going to interpret this. And as they've done that in antitrust, they've used economics as a touchstone because think about it, if you're talking about markets, there is some science to that, and that lies in economics. So, and then in addition, sometimes the agencies will provide some helpful frameworks so that companies understand what the rules of the game are. So, for example, both agencies over the years have agreed on a set of horizontal merger guidelines. So we have some tools. And finally, what I would say about the enforcement is there's really three types, which you saw in the video Fiona was really talking about. One is criminal. There's criminal enforcement of antitrust, and that's where she was talking about collusion, price fixing, getting together with competitors and setting the rules of the game. Much like, of course, if competitors did that in a sport, they would be penalized and probably kicked out. Then mergers and acquisitions, and then anti-competitive conduct, which is probably the most difficult, and we'll get into that in a few minutes.
In terms of that anti-competitive conduct, that seems to be what we're hearing more about. Obviously, there are questions about whether big tech companies, qualify as a monopoly, either under legal precedent or standards that have been issued. But can you give us a better understanding of what is this concept of unfair competition, and what does constitute a monopoly?
Yeah. I'll start with the monopoly. Kind of in everyday parlance, we're very quick to say that someone has a monopoly when they're large, right? Mm-hmm. And being large really is a factor. Not large per se, but what is your market share in the particular market that is at issue? The thing we have to avoid is to say the big is bad, and antitrust really has not done that. What has developed in the courts over the years is an understanding that it requires really two things to be considered a monopolist under the law. One is that you have to have monopoly power. That means you have to have a market share in the relevant market that's typically in the United States upwards of 50%, and that you have some way to control things, that you can set prices without being too inhibited by the competition would be one way to look at it. So that gives you some power, if you will. But the second thing is, because it's not illegal to just be large and to just be influential, you have to then have taken some actions that help you either gain that monopoly status or retain that monopoly status. And those fall into the category that we would call anti-competitive conduct. You might say unfair competition, but we usually call it in the law anti-competitive conduct. And think about that for a minute from a policy perspective. We want companies to want to get big, right? To want to gain market share. Why? Because it drives them harder. It drives them to innovate, to price so that consumers will want to buy and so forth, and to have better service and better products. We want that. So what are we going to do? Somebody reaches a certain size and we say, okay, now we're going to knock you down. No, we can't. That's not what we want to do. When you reach a certain size, the way I like to put it is you have certain responsibilities that come with that. And there's certain types of conduct. Namely, you cannot engage in things really for the sole purpose of excluding other competitors, either ones you have today or ones that might enter. I mean, the reason we don't have a ton of monopolists running around in our country is because in most markets, it's fairly easy to enter. And so if somebody's acting like a monopolist and pushing consumers around, you've got some other innovators coming in and saying, hey, we'll come into this space. But if monopolists, because of their market share, because of their scale, whatever it is, can keep others out unfairly, then that we would consider anti-competitive conduct, and that would not be legal for a monopolist. Does that make sense?
It does, absolutely. And I mean, and I think, you look at examples of some of, especially the litigation that's pending around, the country at both, state suits, and then you've also got obviously enforcement actions happening right now. Can you give us some examples of maybe, cases that have moved forward from an enforcement perspective where it was ruled that this was unfair competition? Like, give us an example of maybe what that looks like in practice.
Yeah. So the phrase, the reason I hesitate a little on the phrase unfair competition, it comes from the FTC Act. And by and large, the FTC has had the foresight over the decades to say, we have to be careful with that phrase unfair competition, because if anybody can stand up and say that's unfair, right? And so what does that really mean? So the FTC up until today has tied itself to the rest of the antitrust laws, which look at anti-competitive. Now, maybe I'm just over lawyering it for you, but I don't want to mislead anyone.
Important distinction. No, I think this is important. Yeah.
And although the current administration actually is trying to change that and say, no, that has hamstrung the FTC, and we want to open that back up again. So so an interesting thing, not something I agree with, but having been there. But so the types of examples of cases that you might see, for example, there's something called predatory pricing. Now, think about this: predatory pricing, setting your price too low. And you say, isn't that really good for consumers? Well, of course it is, generally speaking. But suppose that I'm an airline and I have a hub in a particular airport, and I have a big market share, and you're a little airline and you come in and you have like cool flight attendants and people who sing on the plane and all of those things, and you set your prices low. Mm-hmm. And then I start setting all of my prices lower than you, and I take a loss on that, but I can do it. Why? Because I have so much market share that I will run you out. You will not be able to sustain those prices going lower and lower and lower. And the minute I push you out of the market because you can't make it, I'll raise my prices back up, because now I won't have any competition.
Sure. Right.
So that's something called predatory pricing. We're very careful about that in the law because, again, we generally like low prices, but that would be an example of where a monopolist would go too far.
And don't people make arguments, for instance, that like Amazon and their marketplace has engaged in some of that? I don't want to call it bait and switch because that's not accurate, but you know what I'm saying, where they go and they price things in a way, even within their own marketplace, to drive out even competition, even on their own platform, using their own products, right? You've got some competition issues that have been discussed pretty heavily in the media lately. What's your thought on that?
Yeah, I need to be careful. They're an important customer of P&G, and we work closely with Amazon and are pleased to have that platform on which we do quite well. But yes, my understanding is that one of the primary concerns that some people have claimed against Amazon is that they're not only are they selling other products that other manufacturers like we are making, but they're making some of their own products. And if you think about it, think about the retail stores, the Walmarts, the Targets, and so forth, who started in brick and mortar. They have their own private label products as well, right? And it can be quite lucrative for retailers to do it. So Amazon has some of its own products, and the question that some have raised is, are they favoring their own products? And you could do that in many different ways. One would be put them always on the front page when someone is searching on Amazon. Another way would be you could do it through more favorable pricing. When retailers, whether it's Amazon or brick and mortar, have their own products, they already have some advantage, right? Because they don't have some of the same costs that we have to get on those platforms. It starts with that. That by itself is not a problem. But Amazon obviously has large market share. From what I know, I haven't studied it, but we can all see consumers like Amazon. They like having all of this stuff at their fingertips. And so some have accused Amazon of favoring their own products in that forum. That is absolutely true.
Well, and you mentioned something about the current administration a few minutes ago. I want to kind of go back to that. There is quite a push by this administration, including an executive order that has like 72 initiatives for half a dozen agencies to address what the administration are calling pressing competition problems. So there is quite a wave, and you would even mention perhaps a different approach to antitrust than we've seen perhaps ever, really, with this administration. Can you give us your insight on that, having served in previous administrations, perhaps maybe why this administration is being so aggressive, and then your insight on where this could lead?
Yeah. No, I mean, we haven't seen this type of, I would call it, pro-interventionist antitrust policy, certainly since the 60s or 70s, and maybe it's even different than that. And obviously, I don't know all of the motivations, but from what I do know, I would say a couple of things. First of all, there are folks professors in colleges and universities who have said for many years in both types of administrations, both Democrat and Republican, we just don't think that this is aggressive enough. We think that this favors the companies too much, that an approach that only puts consumers at the center is ignoring some other things that antitrust ought to be concerned with. And so we would take into account more than just consumer welfare, and we would quite frankly intervene a lot more. And they hold the tech companies out specifically as the example of, hey, look at how this company has gotten so large. Obviously, the antitrust laws have failed. These companies have been able to acquire lots of smaller tech companies and get bigger and bigger and offer more and more services. That shouldn't have been allowed to happen. Those are sort of so that has been going on in our colleges and universities. And so there was a big push when this administration was elected for those folks to come in and serve in the administration in the antitrust capacity. And that has happened. Okay. So Tim Wu, a White House advisor who is widely believed to have written that executive order, is one such, and Lena Khan, one of my successors at the FTC, who's now running the FTC, very much in favor of much more intervention, preventing more mergers, bringing labor and other issues into merger review, which in the past has been really more off limits, and also in working with Congress to give themselves more tools. And then the gentleman, Jonathan Cantor, who's now running the antitrust division of the Justice Department, did come out of the private sector from a law firm, but was widely known to have been representing companies who were accusing Google of anti-competitive behavior. So this team started with their worldview. Sure. The administration seemed to share that worldview, and basically what they've said is those of us who were there in the past didn't know what we were doing, and we failed to be interventionist enough to really protect the country. Look, I have a different worldview, and it's not just a defensive worldview. I actually think there's plenty of competition. When I came in, and I promise I'll stop in a sec here, but when I came into the Justice Department, the Microsoft case was pending, the very large antitrust case against Microsoft. And the judge had found that Microsoft had monopolized and said, hey, we've got to break Microsoft into pieces. That case went up to the Court of Appeals in the DC Circuit while we were there, and that came back down. And the DC Circuit said, no. You're going way too far with this. A lot of what Microsoft is doing is good old-fashioned competition. And so we ended up ultimately settling with Microsoft and took a lot of heat for doing it. Right. But today, people aren't screaming about Microsoft, right? And some of the budding tech companies who are screaming about them now are large now and have leapfrogged. So I think
innovation and competition might have a role to play in this. I don't know. It's something to think about.
I certainly think so, and I think that and what I think is just. Look, I obviously enforce the antitrust laws, so I have some belief in it for sure. But again, it's that referee, and not being overly interventionist, because I actually do believe in markets, and I think that I think it's fair to say that the group who is enforcing now has less trust in markets and thinks the markets have gotten out of whack. And they would say, I think, in part because the antitrust enforcers let them do it through inappropriate mergers and the like. So, look, it's a different worldview. I can respect it and not agree with it, and obviously, we'll all see what's next.
Yeah, we'll see how it all plays out. All right. Well, we're going to come back to you in just a few minutes, Debbie. A terrific insight. And thank you so much for helping us get more educated on this framework. Let's shift our perspective to the state level. We're going to be introducing now James Lloyd. He is the chief of the Antitrust Division for the Texas Attorney General. He leads enforcement of state and federal antitrust laws. He currently serves as an intelligence officer in the U.S. Navy and previously served in both the George W. Bush and Trump White Houses, advising primarily on financial regulatory policy. James, I'm so glad you've been able to join us.
Thank you. Really glad to participate.
Awesome. Well, listen, I know we had some tech glitches, so you and I will battle through this together. If we have any issues, we'll figure it out. But first and foremost, why don't you share with the folks that are on this webinar with us today, what is your role in the Attorney General's office?
Absolutely, and thank you too for the chance to come join the members. This is a fantastic forum to be able to get up to speed on some of these new issues that even us in the industry are getting our head around. Well, to highlight our role with the Attorney General. So each state and some of our territories have attorneys generals, and they're one of the 4 ways that antitrust is enforced in the United States. The states are responsible for enforcing our own state antitrust regulations, along with enforcing federal law. States have brought groundbreaking cases on behalf of consumers across an array of industries, from healthcare to pharmaceuticals, energy, transportation, and financial services. And actually, Texas has one of the largest antitrust enforcement shops under Texas Attorney General Ken Paxton. We were actually, the state of Texas was one of the first, along with New York, back in the 1800s to enact strong antitrust laws. So actually, the states led the way for a while, including an interesting fact back in 1845. The initial Bill of Rights of the state of Texas said, "Monopolies are contrary to the genius of a free government and shall never be allowed." Now, monopolies are not illegal. That's what one of the things we get to talk about now is the standards that we set. But that shows you the level of fervor that's been around since the 1800s in this area.
I find it so interesting, right, that we talk about the fervor of antitrust in the state of Texas, when I think Texas would freely go around characterizing itself as this is the best place to do business. And being from Texas, of course, I'm biased, James, but that is very much sort of our marketing ploy, is to go to these other states and especially those businesses located on either one of the coast and say, this is a business friendly state. How do we reconcile that with the fact that Texas is currently engaged in a number of pieces of litigation, if you will, against big tech companies and some antitrust enforcement? So kind of at a higher level, how do we reconcile free markets with antitrust enforcement, especially on this state level?
Absolutely. It's something our team considers almost on a daily basis to make sure we're making that balance, an appropriate balance. I'll say that one of the core principles of conservatism, and that's the angle that I come from myself, like we were talking about, is limited government. However, there's also another core principle, and that's free markets. So the goal of our suits is to address areas where we have seen that there might be particularly weaknesses in our free markets, or a lack of competition, or competition that has not been effectively enforced in the past. And I think competition on the merits is crucially important to our free markets. They drive the engine that drives our country. And one of the primary goals here is by no means to supplant or to disrupt a competitive process, but rather the core of antitrust law and the fundamental goal that we have is to protect that process. And so we're very careful with the kind of cases that we bring. And a lot of times they're quite tailored to very specific issues. And it takes a long investigation process to get to that point.
Well, and something that you shared with me before that I think sort of opened my eyes to the fact that you're looking at litigation as a tool versus legislation, right, as a tool. And could you share a little bit more? You were talking to me of the difference, I think, between a scalpel and taking a sledgehammer to business. Can you give us a little more insight on the difference between these two sort of mechanisms?
Definitely. And I think it goes to the process that we take as enforcers. So on the enforcement side, for example, some of our matters that we have now stemmed from an investigation involving 52 attorneys generals led by Attorney General Ken Paxton, and took years of reviewing the evidence, taking a close look at specific issues that we thought needed to be addressed, and taking action on those. Now, that process will work its way through a long discovery process. Then it will also work its way through the courts, at which point judges can apply standards that we have in antitrust law to couch the action that the state and the federal government can take. And part of that conversation is you reached what we hope is always a nuanced, targeted solution to some of the problems that we see. And that's part of our process when we bring these cases, is we make sure that we consider what are the remedies and how can those be very tailored to make sure that we don't intervene too much, but we can actually see a difference for consumers, keep the free markets free and open and fair.
And how do you contrast that with, let's say, and we'll talk to Barbara Comstock more about federal proposed legislation, but how do you contrast that lengthy, deliberate process that you're describing through litigation and the courts deciding the outcome, applying a long, history with all the precedents in antitrust versus what we're seeing in terms of, even at the state level, some proposals for antitrust legislation that has some troublesome implications, if you will.
Yeah, I think one of those that we have, we get the fortunate opportunity to be a part of the policy conversation nationally. And part of that conversation is to make sure that there's also a deliberative approach to the legislation that goes through. And I know we've spoken with many parties involved in this process to try to strike the right balance. And I think that's the challenge right now, is everybody's trying to get the right answer, but sometimes that takes a little bit of time to make sure that you're not doing unintended consequences with broad legislation to address various particular problems in the market. And I think I describe it as, particularly, I think since our conversation today is focused so heavily on the tech industry, for us, it's like we're on a roller coaster and we're trying to buckle everybody's seatbelts on the second hill. So there is an urgency to solving some of the issues and concerns that have been brought forward. But at the same time, I think urgency can sometimes lead to the concern that to a hammer, everything looks like a nail. And so we tend to apply more of the antitrust policy that has lasted for over a century now, and has been adaptable to a range of industries. And so for us on the enforcement side, that's one advantage we have, is it's an adaptable standard.
And then just one last thing before we move on to kind of our next segment. Can you help us better understand the basis? Most of these suits that, for instance, the state of Texas is bringing against tech companies, let's take Facebook, for example. What's the basis of that suit in layman's terms?
Yep. So out of that 52 Attorney General's investigation that paralleled the Department of Justice and the Federal Trade Commissions, to give you a sense of some of them that have come about. One of them that Texas leads under Attorney General Paxton is a multi-state case of 17 states, bipartisan, that have come together to focus on Google's control in digital advertising. We also have 2 matters with Google's role in search, including one with the Department of Justice and another multi-state into App Store policies. That one involves 38 states. I think an example of the impact of why we pick particular matters is after the long investigations, we see which ones on the merits can be brought to court and fit within our current definition of antitrust violations. Now, in that to give you a color for the kinds of people who come to be part of that process, one example of the cases, our ad tech case has over 200 newspapers that have now filed corresponding lawsuits with Texas, with our Texas advertising multi-state. So that goes to show you the kind of level of interest that we have across markets, because now with such large players, little details make a lot of difference across the economy. And so that's why I think we decided to bring these cases, because they're ripe to be brought before a judge. And they're really critical to seeing a resolution for not only consumers, but other businesses within the marketplace.
All right. I think this is a really interesting angle on this topic, James. And we're going to come back to you in just a few minutes when we have a group conversation. But I want to shift gears, and I think this is a great place for us to bring Barbara Comstock into the conversation. She's a senior advisor with Baker and Donelson and a former Congresswoman for Virginia's 10th Congressional District. She has decades of policy experience in the legislative, administrative, and private sector arenas, and she focuses on technology and cybersecurity areas. As a Congresswoman, she was named the top 10 most effective lawmakers in the 115th Congress, and we are delighted to have you with us, Barbara.
Well, wonderful to be with you here today with my fractured shoulder here, but thanks to technology, we can be here.
I know. I'm so sorry you're dealing with that, but thank you for forging ahead with us. And, I'd like to sort of build upon some of the foundation that Debbie laid for us about the role of Congress. And obviously you have can speak from personal experience about what the role of Congress is in antitrust, and especially as we're looking now at a wave of new legislation. Can you give us a sense of not only the historical role, but what we're seeing right now play out in this new wave of antitrust legislation?
Well, I'd be delighted to. If we were trying to do this panel 10 or 12 years ago, we would have had to cancel probably because we couldn't, we'd have to be in person and I'd have my shoulder. We wouldn't be able to have the technology. But, if I had 10 or 12 years ago said to you, hey, I was in my Uber this morning on my iPhone, booking an Airbnb in London and getting in a quick Zoom meeting before we talked to edit a Google Doc on testimony in Congress, the only thing you really know what I was talking about would be London, because that's how fast the technology world and the ecosystem is moving. That dominant platforms one day can disappear, or, they become more, companies become more diverse and go into other areas. In 2007, there's a great Forbes magazine cover that you can look up. You can Google it, or you can go on Bing or DuckDuckGo and probably find it too. But it's the president of Nokia holding the flip phone to his ear, and it says, can anyone catch up? They've got 1 billion users. Now we have over 7 billion smartphone and cell phone users around the world, and it's growing. Nokia's gone. It was gone after a few years after that, but we have Apple and Android phones. So the speed of innovation and what these companies are doing are incredible. And the reason I like to highlight all of this is because Congress has about a 10 or 20% approval rating. The approval ratings of these companies, which are in the 60s, 70s, even 80s, are something that, any state AG would die, or governor would die for, or any politician. These are well-run companies, among the best, dynamic, huge ecosystem, big, small, and medium. They're creating jobs right now. They're investing in their workers. They have great healthcare benefits and other benefits, telehealth, mental health, 401ks, paid family leave. How many people have, how many companies have 4 or 5 or even 6 months paid leave? These companies provide that just to their entry level all the way up.
Right.
We're now paying for college. Elizabeth Warren and Bernie Sanders want everyone to pay for college. Well, if you work for Google or Amazon, they have new programs, or they've set up because they want to upscale their workers, and they realize investing in your workers and promoting their opportunities are what we all have to do in the post-pandemic world.
Well, and Barbara, the role, though, of Congress right now, if you can kind of zero in on that for just a second with me, because there is this really big focus, and you've got Klobuchar's bill and things of that nature coming down the pipeline. Why don't you explain to us what is sort of currently being proposed, and then we can talk about the viability of that in a separate question, but explain to us what that current landscape is in Congress.
Well, the main congressional bills are the Democrat one in the Senate, in the House, in the Senate, but they also have bipartisan support. Amy Klobuchar's bill in the Senate, for example, basically guts the consumer welfare standard. And we haven't really addressed the consumer welfare standard and how it came about, but it came about from the scholarly work of the great late Judge Robert Bork. And his son, Robert Bork Jr., now continues to work on these issues today. And the consumer welfare standard, as Bork put it, antitrust law shouldn't try to decide who is worthy or to defend smaller or less efficient competitors. The aim of antitrust is to protect consumers. But Amy Klobuchar, and if you read her antitrust book, I'd encourage, all the attorney general's offices to read it, particularly the Republican ones, because she thinks we need the bill because of bad conservative judges who she doesn't like how they decide these things. Now, in a recent antitrust case, Justice Gorsuch reinforced that consumer welfare standard by saying to the state AG, the antitrust laws are aimed at protecting consumers. You'd agree with that. We're not here to protect competitors, right? So that's Gorsuch, somebody who Amy Klobuchar voted against. So she wants these new laws. And I think that something to this effect is in her foreword where she says, yeah, consumers like these, but they don't always know what's good for them. And even though they're very popular, us unpopular people in Congress maybe need to run your life a little bit more. And that's what really, I think, is threatened here. Just the self-preferencing issue that we were talking about, which has always been in your grocery stores, in your drugstores, in any stores.
And that's self-preferencing, meaning it's almost like a virtual end cap in a store, right?
Right.
Is that fair?
Yeah, Coca-Cola wants to be on the end aisle.
Right.
So now online you have those kind of things too, because they've built the systems and they're doing this. So they want to say, you don't want to prefer Google Maps over others. That if you go on Google and you want to Google restaurants near me and they connect you right away to that Italian restaurant, you say Italian restaurants near me. You get it. The Google map goes there. It also tells you what time they're open. And thanks to a lot of the Google tools used during the pandemic, you can put your a lot of free tools. You have your menu on there, everything else. These are the kind of things, be careful of unintended consequences, which would be threatened in these new bills. They want to separate Amazon Prime and Amazon Video, things that we've all come as consumers, I think it's 150 million Prime users, to adapt to. But it also disrupts the whole ecosystem because you have small sellers, say, for example, on the Amazon platform, who go on there, and even though they're not warehousing all their things on Amazon, they can go on there and get access to all of the people who are on Amazon just by joining and going online and selling. Maybe they only sell a couple hundred things a month, but they can now have access to that. They don't have to warehouse. So all of these things are going to be disrupted in this bill. And as Senator Mike Lee, sort of the leading Republican conservative in the Bork mode, has said, they don't want to break up tech to protect us, but to control it and use it against us. We can't, it's really moving things into the big government, which is why it is so bizarre to see Republicans fight what was a free market standard that for 40 years has given us the best economy in the world. And I would point out how much these bills, as well as some of what the state AGs are doing, are like the European Union approach to antitrust.
Well, and that actually is a question that just came up in the chat, because that global competitiveness is a factor,
Yes.
right? Obviously, we're looking at the impact on consumers. In a minute, I do want to come back to the impact.
Yeah, and I point out 20 top companies, 20 top tech companies, 11 US, 9 China, our biggest competitor, zero AU. So it's as if in these bills, they're saying in these lawsuits, what can we do to be more like the losers in this competition instead of the winners? And we can be winners and still, as Deborah talked about, you're still going to, if there's predatory pricing, if there's issues, you can bring lawsuits. The current, and I would point out, these state AGs have to operate under the current law because there is not new law. They may be advocating new law, but they're operating under the current law where the Bork consumer welfare standard has been adopted for 40 years in Democrat and Republican administrations, Clinton, Obama, Reagan, Bush. And it's served our economy well, grown it by 3 times in the 40 years, grown salaries. And these companies themselves, we need them to be competitive to deal with the China threat, the national security threats we face. The European Union, as we're seeing this week, isn't as good as dealing with these. They need us, and we need to be. I don't want to be in a world where the U.S. isn't the dominant, prominent leaders on technology, on national security, on defense, on all of these tools that where these companies are the R&D leaders in the world that keep us competitive.
Well, let's talk a little bit about competition, because there's some data points that come out of this administration to support the executive order and some of the initiatives. And one of the facts that they point to is that new business formation has fallen by 50% since the 70s, and that it is more difficult for smaller businesses to sort of break into these markets. In fact, I spoke to a friend who is a COO and they're starting a new search engine, which we know that's a challenge, right? You've got some behemoths out there. So what do you say to those that claim, look, it's not about zero, modifications to current antitrust, but it's a spectrum, and that there's somewhere on this spectrum that we need to land somewhere between over regulation and doing nothing at all? What do you say to those people that say that innovation, maybe isn't the end all be all sort of outcome here?
Well, then we won't be the leaders of the world if we don't put the priority on innovation. And President Biden, I point out, who unfortunately sounds like some Republicans these days on this, said 40 years ago, we chose the wrong path following the misguided philosophy of people like Robert Bork, who said the consumer welfare standard was the one that works. It has worked. Pre-pandemic, our economy was growing leaps and bounds. I've seen, in the area where I both have lived for 30 years as well as served in Congress and in the General Assembly, State House in Virginia, have seen the ecosystem, like our tech council in Virginia, in Northern Virginia, and it's mostly small businesses. Now, sometimes these small businesses want to sell to the big guys. Sometimes they want to become the big guy themselves. Yahoo had an opportunity to buy Google and said, nah, we think we're better. We're going to pass on that. MySpace thought, hey, we're dominant. We're going to do great. Then Facebook came along. So, we're here today on a platform. This is my first time I've ever been on StreamYard. And I know this platform interfaces with LinkedIn and Facebook and multi-platforms. And this interfacing and doing all those things, there's just a market for all kinds of things that continues under our current system. Now, if people try to do predatory pricing, they cheat, they don't do things right, you can give more money to actually go after some of the real antitrust cases. Sure. But, right. In Texas, just to put, the Attorney General wanted $43 million to go after these tech companies. At the same time that you have the governor and others and say, hey, come to Texas and do everything here, and we're business friendly. I mean, I think people in Texas might want that spent on the grid, maybe, or,
okay. All right. It's freezing here today, Barbara. Don't get me nervous about my power grid. All right.
Yeah, so, no, but when you talk to the American people about what they want, breaking up big tech is not on their list of things to do. And in fact, these companies are exponentially more popular than the politicians.
Well, I appreciate that. Let's bring everybody else into the call here or onto the screen, because this, I think we have an interesting point, and I think James wants to respond to maybe one of the last points that you made, and we'll do that quickly because then we want to shift to people's questions. But James, I got to give it back to you for a second.
Yeah, I think I appreciate the fervor sometimes with trying to strike the right balance here. And I think that's what we really try to do here. The reason they cost so much is these are some of the most complex cases ever brought, in a sense, and they're very rarely brought. You have to gather up a bunch of states to do it. It takes extraordinary levels of expert witnesses, of experts and discovery. So the process is necessary. It's one that antitrust does as industries have developed. I think one of the things to realize is that they are powerful. The CEO of Google, many times over, both the founders and Sundar Pichai have said, with size comes scrutiny. They understand it. The same thing has been said by Facebook CEO. So it's part of the process where as you get to a point where you control so much, part of that process is we do look to make sure that that you're playing within the marketplace under the current standard. The consumer welfare standard is one that we do address and really hold to a standard when we bring our cases. And so I think that is where there is a point where you have to you do have to ask certain questions, and that's what we're doing now.
I appreciate that reply, James. And I think it's really helpful for our community, right, to hear different perspectives. So I'm grateful that each one of you is kind of shedding light on different angles. I'd like to kind of do a quick lightning round. So everybody's kind of, it's like a minute to reply to this. And then we have like two really great questions that I want to pose to y'all. But the first one I want to, Debbie, I would like you to go first. So some of our members, I bring up antitrust and they're like, oh, that gives me a headache. Why should I care? Right? It's not exactly the most exciting concept until we start talking about what the impact could be. So I'd love for you to, talk to my average community member, and, she lives in Cincinnati and maybe your hometown. Why does this matter to her?
Yeah, look, consumers and, let's face it, voters, really what we know in election cycle after election cycle, or in the marketplace, they care most about their taking care of their families and what it means for them. And so they care a lot about the state of the economy. And so why I think this is so important to consumers is, as voters, it's really, and those who can affect the public policy, and hey, we the people should be doing more of that. It's to make sure that those in Washington or in our states can strike the right balance. Because yes, using the consumer welfare standard, think about it, the center of antitrust is to protect consumers. But on the other hand, and we've just learned this in the pandemic, right? Don't protect us too much, right? Let us make choices too. So the key to antitrust, I believe, is to strike that balance so that government is the referee, once again, ensuring that we have competitive markets, but not going so far as some of us believe other countries like across the pond have done, which then results in not having the innovation, not having these kinds of companies. You need to strike that balance. And that last one, that point that Barbara made, it's an important one, because it's hard for us to sort of see the longer term. We can very quickly see, yeah, I want you to protect me, right? But protecting us too much to the point where the government is doing too much market engineering will, in my opinion, and I believe all of the panelists seem to agree with this, would go too far. And so we have laws in place, like James said, to enforce the antitrust laws. Let's enforce the antitrust laws we have. They're very adaptable. And let's continue to talk to each other and strike that right balance.
I think that's the balance and the trade-offs is so key for each one of our listeners or whoever's watching us today to think about those things and make up their own mind. What are those trade-offs and where do they land on this spectrum? Barbara, when we look at sort of practical implications, right, of proposed legislation and the things that I know you're fighting against, why should consumers and voters, to Debbie's point, care about antitrust?
Well, because we have this great tech ecosystem that has gotten us through the pandemic, which is, the fastest growing jobs out there, providing all these good benefits to our economy and to international competition. Beware of unintended consequences, and particularly with the legislation. For example, the legislation was voted on, for example, in the Senate without a hearing. So without bringing in people to listen to, it's kind of rushed, it's very politicized. And the real concern about this is, if you go away from the consumer welfare standard, as these bills would do, gutting it, and that's coming from Robert Bork Jr. as well as many of the conservative, as well as actually Larry Summers, a Democrat economist, has said these are a bad idea. But if you do that, you could disrupt this system that post-pandemic we've all become, what we hope will be post-pandemic, very dependent on. And these companies that allow us to be the leaders in the world, I think, are very important. And there's two different rules in these bills. If you're big, you have one set of rules where you're presumed guilty. We're not going to we're going to really make it hard for you to merge. We're going to have huge fines if you do something wrong, or very vague standards. And so you're going to be spending your money on heavy regulation and more lawyers and instead of innovation, which is what we need in the healthcare space and in the cybersecurity space, in the international, look what we're dealing with now, thanks to all the mapping technologies, open source things, we can, you have people in real time on Twitter showing you what's going on the Ukraine border. This is a good thing that we have, and let's really thoughtfully, carefully, and slowly, not mess this up, because people want to make some talking points, and particularly for conservatives who are largely concerned with content moderation. Antitrust is not the solution to content moderation.
Okay, that was one of the questions that actually has popped up. I've seen
it has
several
nothing to do with it.
About that. And
if
so
you have an issue with that, there's whole other bills for that.
Yeah. And we've got a whole other move the needle on big tech and free speech.
And this is about competition. And make no mistake, Amy Klobuchar and Elizabeth Warren, and unfortunately some Republicans, want to go after big oil. Maybe Texas might not like that. They want to go after big agriculture, big pharma, all of these, they honestly do think big is bad. Wow. And as Deborah pointed out, that was never intended to be sort of the underlying law. And you see some very troubling statements and actions already by Lena Khan, a 32-year-old academic who hasn't been out, running businesses. And even those who run businesses in this field can, it's challenging. So the idea that somebody who's never been in this field is going to come in and tell you how to run it.
Right. I get that we've got some interesting players, right, in that space right now.
And it's all about big government. These bills are you're going to trade. If you don't like big tech, well, now you're going to hand all this power to big government. Yeah. Maybe not such a good idea.
Well, James, and on the level of empowering our community to think about this at the state level, you and I discussed this yesterday. This is a tough topic. Some things we can handle and say, okay, here's some action items, right? Here's some things you can do as a citizen, a voter, a consumer. Let's think about the state level and perhaps some ways that people listening today, if they feel activated or they feel strongly about some of the things we've discussed, what are some things that people can do at that state level to perhaps influence public policy or be more knowledgeable about what their state is doing in antitrust?
I think they've taken the first steps by just learning about what are the questions that are coming up. What is the issue? So everybody on this call are such extraordinary parts of that conversation. And we hear it on a daily basis, on an hourly basis, particularly as somebody myself who comes from more conservative, is striking that balance and finding to make sure that the right cases are brought, that the appropriate legislation is put through, that the appropriate targeting of that legislation. And I think what's important is that there are plenty of people out there who mean well. But I think that it helps when people understand the debate. And I think this is the first step, is really understanding where in the spectrum do you fall? So you ask yourself, do you want more intervention by the government, or do you believe that these problems are best handled by the market itself? And there's a spectrum on there. So my family, I come from a family of lawyers. My mom, my sister, and my dad are all lawyers, including with myself. And so we might come to separate conclusions, each within our own. All four of us will come to different conclusions. But I think that staying informed about the cases and how they relate to issues that you see in certain markets, so even beyond big tech, for example, in healthcare and other areas that we take a look at, to see when you read that newspaper and you say, okay, this is why the government, either the enforcers like us who enforce the law as it's written, or those who are shaping the next law, how does it impact not only the issues that you find important and that you want to bring forward, but to make sure that within that spectrum that you choose, more intervention or less intervention, where do you fall on that? I think understanding that and being able to advocate in that manner really helps. And just in knowing those issues, because they're going to come up a lot. They've come up for pretty much ever since the 1880s. And so they came up in batches. And so I think this is one now where just being informed helps so much.
Well, listen, I am sitting here looking through our questions, and you guys have addressed all of these, which is really pretty great. And especially, I think there are some questions on here about privacy laws. There are some questions about free speech. And I would encourage folks that are sort of tuning in to us today to go on our YouTube channel. We actually had Steve Del Bianco from Net Choice, who frequently speaks on this issue, alongside several really interesting voices on this topic. So look at our YouTube channel and you're going to see a whole conversation about big tech and free speech, because you're dealing with a completely different legal framework. And all these times these get confused and convoluted, and there's definitely some animosity towards big tech and that free speech arena that might be fueling some of this bipartisan support of controlling big tech. We're two separate issues. And so the one thing I would love to just to say to our panelists here today is really appreciate that you guys are sharing with us all the different things that we need to be considered when we evaluate policy and when we evaluate a movement. And the type of information you've given our community today is so valuable as we encourage women to be more informed so they can step into the arena and be credible and effective. So thank you to all three of you. We are almost out of time, and so I'm going to give it a wrap. So thank you guys so much.
Thank you.
Thank you.
And if you found this conversation today to be worth your time, if you found that this is the type of topic or any topics and you think, gosh, I really want a reliable source and I want to engage in substantive conversations, I sure do hope you'll consider joining our Policy Circle community. We have a number of ways that you can get on our website, learn more about us, perhaps join and donate. And we have an upcoming event that I want to make sure you put on your calendar. It's March 31st. We're hosting our first Circle Up America experience. And there's really three ways you can join us. First, you can join us by registering for a virtual circle on the antitrust brief. So you'll get an opportunity to try out our roundtable model, read the brief, and interact in a virtual setting. We have two different times that you can register for. I believe it's noon and 7 Central. And then the other thing that you can do is you can also sign up to host your own conversation. Easy, simple. We send you a little kit. All you have to do is fill out a simple form. But we hope you'll join us on March 31st as we dig into the antitrust issue a little bit deeper and then personalize it to find out what can we do in our community. And then the last slide that we're going to show you today is how can you take action on this issue? These are some things we suggest you do. Obviously, reading the brief and hosting a conversation. Contact your representative, your senators at the state and the federal level. You will be surprised how much they want to hear from you on these issues. Your comments, your opinions, they matter. Also, write op-eds. Citizens need to be commenting on this. And again, like we discussed in the panel, shaping this debate in an informed and thoughtful way. And you can actually go on the Department of Justice and the FTC's websites. There are opportunities for public comment, and there are a number of resources where you can actually report antitrust violations. So as a citizen, you can be much more engaged in this probably than you realize. And we're grateful for your time today. We're grateful for your contributions to our community. And we look forward to seeing you hopefully on the 31st. Have a great afternoon.